Very deep.
I won't take really much time after all the judgments have been read. I'm appearing for an intervener, Maharaj. Which is that application?
This is 56615.
IA 56615. 56615.
Dr. Singhvi, when you are appearing for an intervener, you have some other proceedings pending before the court? Or?
Yes, Maharaj, actually my matter was referred by your lordships to the arbitrator.
I think Dr. Singhvi was appearing for Kiloskar brothers, right?
Yes.
Pending.
Whereas I am
You have a matter pending.
Yes, it is coming in fact 2 weeks later also.
Whereas mine is the matter which your lordship sent back, which my learned friend has referred that order in ONGC. That's the matter which has gone back to the arbitrators, for which a review is pending.
The review, we thought we'll await this for the review. That's why the review is still.
I understand that. I'm not saying anything else to that. I'm not going to argue on any of it. We are not for ONGC, because I am for the other party.
Oh,
R2.
R2, Maharaj, the Jindal group.
the Jindal group.
Yes, which your lordship allowed the ONGC appeal, sent it back. Now that discovery proceeding is taking place. But Maharaj, let me start off by saying that though I am in support of the doctrine, group of companies doctrine, Maharaj, I think we need to tick a little. Let me put it that way.
Yes.
Whereas in ordinary law, a litigant is given no choice to choose the court where he wants to go.
Can I take your lordship's leave, Maharaj?
Yes, sir.
Statutes decide that all litigants dealing with commercial matters go to this court. Suits are filed in civil courts. You can't choose your judge. You can't choose your procedure. That's a given. That's the law of the land. But when you come to arbitration, Maharaj, conceptually, the whole proceeding is based on choice. You choose the forum, you choose the applicable law, you choose the seat of arbitration, you choose the arbitrators, and a procedure on which a third arbitrator may be appointed. It's a matter of choice. Choice is at the heart of an arbitration proceeding. This concept, Mullers, has not been recognized. What has been recognized is intention, not choice. Cloro and all subsequent judgments talk of intention of parties. In this context, Mullers, kindly read 2H and 7 with me. To H says party means a party to an arbitration agreement. Nothing more, nothing less. Doesn't talk of a signatory to the arbitration. No, doesn't talk of that. Now come to Mullers. 7. In this part, arbitration agreement means an agreement by the parties, again doesn't talk of signatories, to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. So there must be a defined legal relationship between the parties. It can't be a divorce the parties. That may be contractual, it may not be contractual. But there must be a defined legal relationship. that I will supply this material to you under the mother contract. That I will perform this service for you under the mother contract. But there is no defined legal relationship that can be enunciated in the course of a proceeding, Mother. You'll be out of the chloro doctrine. Because obviously there's a difference between a defined legal relationship and a contractual relationship. The mother agreement says that my affiliate is going to supply you the material. It's part of the mother agreement, part of the contract between the parent company, the mother company, as well as the recipient of those of the supplier. Supplier is identified. It has a defined legal relationship. It enters it saying that I will be supplying you on such and such, such and such. It's suo motu. There's no contract, but it says that the terms of the supply will be that every 3 quarters, every quarter I'll supply you X amount of the material. It's part of the agreement, Mullahs. Situation is different. Now read Mullah 7.2 with me. An agreement, an arbitration agreement, may be in the form, I'm sorry. An arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. No problem. Then an arbitration agreement shall be in writing. That's very important. Arbitration agreement shall be in writing. An arbitration agreement is in writing. Kindly, let's mark the words. Is in writing if it is contained in a document signed by the parties. So that creates the problem. An arbitration agreement is an agreement in writing. It is in writing if it is contained in a document signed by the parties. If it is not signed by the parties, it is not in writing. If it is not in writing, it is not an arbitration agreement. If it's not an arbitration agreement, I can't be saddled with the responsibility of having to go through the arbitration process. However, if it is part of a composite whole and there is a defined legal relationship with reference to a mother contract, the doctrine applies. Now we know, Mullahs, the signed by the parties is a sine qua non. Now that signature of the parties may be on the document itself. It may be by emails and through other forms of communication like telegrams and everything else. That provides the record of the agreement in writing. That may not be mentioned there, but that's what it says. That's what it means. And then an exchange of statements of claim and defense in which the existence of the agreement is alleged by one party or not denied by the other is post the matter going to arbitration.
So according to you, there has to be the existing defined legal relationship.
That's right. That's fundamental, Mullahs. In the absence of that, Mullahs, I give you a lordship just a small example. Supposing, Mullahs, the government of India, Mullahs, floats a tender. When it floats a tender, Mullahs, the conditions of the tender are set out. They also say that if you want to supply, you can have an affiliate. The details of the affiliate have to be mentioned. What the affiliate is to do is also mentioned. And let's be clear, most of these agreements are vetted by lawyers, not overnight. These negotiations go on for months.
So you're saying it's a twin test?
Yes.
One is that there must be a defined legal relationship.
Yes,
Second is that it has to be signed,
yes,
and that signature need not be in the original formal contract,
absolutely.
but it can be reflected in what all mentioned in B,
Correct.
which constitute a record of the agreement.
Correct. That's my limited submission. The reason is simple, Manoj. And your lordship put it very well, Manoj, that we are not in a 226 jurisdiction. And when Chloro talks about doing justice between the parties, it's outside of 7. We are not in an equitable jurisdiction framework.
So that justice is really understood in a more restrictive sense in the context of giving business efficacy and business meaning.
That's fine, Manoj. I'm not against that, Manoj, but we should not.
Order.
That's right. Your lordship need to clarify that. That's all that I want.
Public law justice.
Yes, your lordship needs to clarify that. That's all, Manoj. Justice should not mean that the judge feels that no, unless I bring in these parties, even though they are not
Not
signatory.
equity.
Yes, no equity involved. Choice is paramount because choice will be reflected, Manoj. In the communications, choice will be reflected in the relationship, choice will be reflected in the.
Yeah, that.
Actually, clear intention of the party in
That's-
furtherance of the contract.
That's correct. That's correct. That is correct. The word intention, Manoj, has been used all along, Chloro onwards.
To give the contract a sense of business efficacy.
Yes, correct, absolutely. But not in the context of, Manoj, of choice. Not in the context of choice. Therefore, Manoj, once Chloro was decided, all other judgments followed it. And Manoj, both Justice Surya, as well as Manoj, the majority judgment, say that Chloro is doubtful.
No, Justice Suryakant doesn't say it is.
Yes, para 20.
What he really says is that there may be some little inconsistencies between the different judgments.
Yes, sir. The para 28 says exactly that. That needs to be clarified.
Yeah.
No, in this context, that's what the judge says. I'll read it, Manoj. Your lordship need not trouble yourself. Para 28. Yes.
What page
He
is
says, at the outset, it must be candidly acknowledged that certain inconsistencies do exist in terms of the judgments
Where are you
of the
reading?
court. No,
Where are you
let me read on. Regarding underlying basis of the group of companies doctrine, for instance, in Chloro controls, the court seemed to adopt a contradictory positions. This is not just that, Manoj. Courts seem to adopt contradictory positions in terms of when a third party may be bound to arbitration agreement. On the one hand, the court emphasized on the intention of parties to include the non-signatory party, but on the other, it went on to add that non-signatory may be added to the arbitration proceedings without their consent in exceptional cases. Thus, it seems that Chloro controls places a premium.
Which para was that?
This 28, Manoj. I know your lordship might have missed it.
No, I was just noting, that's all. 28. You are reading the court's order?
Yes,
in the
I'll read it
compilation.
again, Manoj. Yes. At the outset,
The
it must be
compilation.
candidly acknowledged that
Your paper of page 920.
Nine twenty.
920.
Can I read it, Manoj?
Yes.
At the outset, it must be candidly acknowledged that certain inconsistencies do exist in terms of the judgments of this court regarding the underlying basis for the group of companies doctrine. For instance, in Chloro controls, the court seemed to adopt contradictory positions in terms of when a third party may be bound to the arbitration agreement. On the one hand, the court emphasized on the intention of the parties to include the non-signatory party. But on the other, it went on to add that non-signatories may be added to the arbitration proceedings without their consent in exceptional cases. Thus, it seems, 84 of the report. Thus, it seems that while Chloro controls places a premium on the intent of parties, it also advocates taking an equity-based approach to discard intent completely if so required in the interest of justice. And as your lordship knows, the majority says that in any case, Chloro need not be followed. But I don't want, Manoj, I'm not taking those extreme positions.
Very reflective of Chloro.
Taking those extreme positions, Manoj.